Good afternoon, everyone. Hi, a very warm welcome to the webinar. My name's Simon Blanchard. I'm a partner at Data Protection Network Associates. I've been with the business for around about 9 years now. So the DPN team, we produce and publish lots of very practical kind of guidance, updates and material for organizations, covering a wide range of data protection, privacy related topics. You can see our website if you'd like more details, which is dpnetwork.org.uk. We're also a data protection consultancy and a training provider. We work with a wide range of organizations of all kind of shapes and sizes across many kind of sectors of the economy too. So I'm just going to pop some slides up for us now, just really to set the scene on the topic that we're going to discuss today, which is how to manage suppliers and service providers. That's the topic that we're going to be covering. I am actually very mindful that some of you that are joining us today might be in broader roles, broader ESG, compliance or legal related roles. Just to make it clear that today we're really going to focus on the data protection, privacy related aspects to supplier management. Although we appreciate there are other kind of angles and other kind of lenses that you might look at this topic through. The webinar is being recorded today, so if you'd like to view it again, or if you'd like to, share it with colleagues afterwards, you will have an opportunity to do that. We'll be dropping you an email around about this time tomorrow, so that you can, so that you'll be able to have a copy to the, view the recording at your own leisure. Thanks ever so much for anyone that submitted any questions in advance. Those are really useful to kind of help us kind of plan out the webinar. So we've got those kind of planned, but equally, if you've not submitted a question, you've got an opportunity to do that. You'll hopefully see that there is a chat button enabled there for you. If you want to pop anything on there, please feel free to do so. Drop us a line with any questions that you have, and we'll try and get to as many as we can in the time that's available. I'd also like to say a big thank you to our sponsor, who are DPOrganizer today, and I'm just going to tell you a little bit about them. So DPOrganizer is a full suite privacy management solution that's all about giving privacy professionals everything they need to be more effective in their everyday work. It's an easy to use SaaS solution that can be implemented in days, and a professional services team of data protection lawyers will make sure that you always have access to extra knowledge and resources. DPOrganizer is actually hosted and supported from Europe, with a team in the UK as well that can support you with data mapping, risk assessments, workflow automation, e-learning, data breach management, DSAR management, and much more. Okay, and there's a link there for you too. So let's move on and just kind of introduce you to the panel. First of all, I'd like to introduce our chairperson for the event, in fact, our regular chair with us each time we do one of these, which is Robert Bond, who's a very experienced and respected privacy lawyer. Robert, do you want to say a few words to introduce yourself?
Thank you very much, Simon, and thank you for asking me to chair this webinar. I'm Senior Counsel with Privacy Partnership Law. I've been doing data protection for 40 years now. And I'm also an industry commissioner with the Data and Marketing Commission. So I do adjudicate complaints against inappropriate marketing and advertising.
Great. Thanks very much, Robert. Great to have you on board again. I'd also now like to introduce Egil Bergenlind. I hope I've got that right, Egil. Yeah. Would you like to introduce yourself and tell us what you mean by privacy hero sidekick here on that? It'd be lovely to hear.
Isn't it obvious? No, but yeah, I'm one of the founders here of DPOrganizer. I've been working with data protection law for the last 12 years, and now, making sure that we help privacy professionals. I mean, today we're talking about vendor management, which is much about how do you support the business while making sure that we don't violate the privacy of people, and this is often what privacy professionals do, like help companies find the right balance, and this is why we think of them as privacy heroes, and we want to be their sidekicks, provide them the best possible tool and support. So yeah, there you have it.
Brilliant. Lovely. Thanks for telling us. That's good. And last but not least is Dominic Batchelor. So Dominic, would you like to say a few words?
Thanks, Simon, and hi everybody. As the script says, I'm head of IP and privacy at Royal Mail Group, and in this role I deal with a wide range of data protection matters in a business which is one of the largest employers in the country, and which also processes the personal data of millions of customers every day in delivering their mail. I've been involved in data protection since not long after the 1998 Act came in, which is closing in on a quarter of a century ago, both in private practice and in my current role. So I've looked at this sort of matter both from the supplier side and the customer side, and I'm looking forward to sharing some of that experience today.
Terrific. Right, great. So we've got a really good panel here to kind of share their thoughts with you all today. So next, I'm just going to say, just pop a few slides up. This is not going to be death by PowerPoint by any means. I'm just really to kind of set the scene on what we'll talk about today. So the first kind of question that we sometimes get is, what do we mean by suppliers in terms of supplier management? And this is just really to recognise that that we might use, suppliers, service providers, processors, as we might call them in data protection terms, for all sorts of different, teams across a business. So HR, finance, marketing, R&D, whatever they might be across your business. And we, many of those teams will appoint providers, either technology providers or other service providers, to manage data on behalf of the organisation. In terms of what good supplier management looks like, again, very much what we're going to talk about today. So we'll touch on some themes around due diligence. What should due diligence look like? Contractual requirements and international data transfers we'll talk about. Maybe the role of certification, security certifications and others too. Supplier management in terms of checks and audits and what should that look like. I'm not going to go through the detail, but these are kind of some of the key areas that we'll be looking at on today's session. We'll also touch on, in terms of the contractual requirements that we have particularly under the UK and EU GDPRs. We'll come on to that a little bit more later on, so I won't go through the detail of that, but it's certainly something that we really keen to focus on today. And just pointing out, so why are we doing this? What kind of risks can there be in the supply chain, particularly, for controllers, but equally for processors and sub-processors? Probably the one that comes to mind initially is the risk of a data breach, and of course there's been quite a number of high-profile ones of those in the press lately. 54% of organisations that were surveyed said they'd suffered a breach caused by a third-party supplier. So you might even find that those stats are higher nowadays. That was in 21-22. So with the number that we've seen, could be even more. And there's a couple of high-profile ones that we've seen. There's Ellis and Met Police ones if you're UK-based. But equally, that's not the only thing that we're talking about here. There are other risks involved, like the risk that data might be used by a processor in the ways that the controller had never wanted, never agreed to, and just didn't expect to happen. A failure to delete a controller's data at the right time, unauthorized sharing of information, or sharing without adequate security and controls in place. There's a number of different areas that might be, areas that we might want to consider. But again, we'll come on to all of that later on. So without any further ado, I'm going to hand over to Robert to share the panel discussion.
And indeed, before we do that, we've got some polls.
We have. Yeah.
Can we launch the first poll? And please, by all means, respond. It'd be nice to see what your thoughts are with poll number 1, please, Simon.
It should be live now, Robert.
Yeah. So does your organisation have a standard due diligence process for new suppliers which covers data protection and security? And as I see the answers coming in, thank you. It's good to see that the vast majority do. So maybe we've got nothing to teach anybody in a minute. We'll see.
Should we end it there?
Yeah, I think we're pretty much there. So 82% of you say yes, 9% not sure, and 7% no. Okay, so let's look at the next one, please, Simon. If yes, is this a one-size-fits-all solution, or do you tailor your due diligence to the different types of supplier, or indeed the different categories of data? And a slightly different percentage here. It's, oh, well, I was going to say it's only just about majority one size fits all, but let's give it another. Yep, there we go. So about 44 one size, 42 tailored, 12% not sure. And we'll get feedback from the panelists on, is it one size or do you tailor, shortly. And then I think you've got one more, Simon.
We have, yeah. Just going to publish the final question. There we go.
So does your organization conduct any ongoing assurance activities after contracting with suppliers? So that's an interesting one. Do you do a one-off audit, or do you make this more persistent or more regular? Slightly more balanced here. So 34 yes, 38% partly, 27% no. Thank you. Thank you for those. That's great. And we'll bear those in mind as we excuse me, move into the questions. And let's start with one of the first questions which we had in, which at a high level, and I'll go to Dominic first. Why do you think it's important to manage supplier relationships properly, Dominic?
I think before we even get to data protection, there's a business common sense reason for doing this. If you're entrusting something that's important to your business to a supplier, you want that supplier to do a good job, because if a supplier doesn't, it can impact on your business and your reputation. If we then look at data, if you're entrusting that supplier with your customers' information, your employees, your people's information, and something goes wrong, you can see how it could be very harmful to the business. If we then look at data protection on top of that, we have legal obligations as data controllers, which I would take it to be the case in the context of customers looking to use suppliers to provide services, to ensure that the personal data they process is processed appropriately. And many suppliers will be processors of those controller customers. So there is continuing responsibility for the conduct of those suppliers and that their performance is up to standard. Simon, you briefly went through some contractual requirements further to Article 28 of the UK GDPR, and those set out some particulars about the sorts of things that would be required in that sort of supplier supplier process of relationship. Fundamentally, the controller is required to ensure that the supplier assures appropriate technical and organisational measures to keep the data secure, but also helps with some more practical things, such as assisting with subject access requests and other exercises of data subject rights, impact assessments, notifications to the regulator in case of security breaches, that sort of thing. So there's quite a lot there that the controller customer is dependent on getting right. And in order to get that right, it's important to understand your supplier, what your supplier can do, where you might need to make additional provision to ensure that the standard is up to where it needs to be. And as I'm sure we'll come on to later, other measures to ensure the relationship is successful and you can deal with any issues as they might arise.
Okay, thank you for that. And I'm going to ask Egil, from your point of view, why must we manage the relationship?
Yeah, but I fully agree with what Dominic said there. And just to add to that, I think the business aspects of this is very important to keep in mind, that our suppliers, our vendors are someone that we want to do business with, that we rely on, and that we need to be able to rely on. So we need to select them carefully, and we need to be able to trust them. And we see all the time how legal teams and privacy teams that we meet are struggling in getting in at the right time in order to do their due diligence and spend the right amount of time on reviewing agreements, checking security measures, etc. They spend a lot of time on this, but often they get involved too late or too little in order to be able to support their business colleagues in a good way, which leads to delayed processes, which results in less business value or worse customer relationships, etc. So managing this is something that takes a lot of time. So if we can be better at planning when and how do we want to do due diligence in this area, how do we want to manage our vendor relationships, then we can both manage the risk better, spend our resources where they should be, and we can also be more efficient in supporting the organization and building better relationships with these vendors that we are dependent on. So that's why it's very important.
Yeah, I mean, I like the fact that it's not all about the negative side. I can see you're saying actually what we're doing here is trying to improve the vendor relationship. Thank you. Yeah. And anything you'd like to add, Simon, to that?
I don't think there is too much, if I'm honest. I think both Dominic and Egil have covered that really nicely. I mean, I was going to talk maybe a little bit about kind of risk management from that point of view, in terms of protecting our business reputation, protecting our staff, and obviously our customers at the end of the day. But I think you've probably said all that needs. So let's move on.
So while we've been talking, one of the comments that came in was I've got my doubts about the one-size-fits-all approach, and I wonder, Egil, what's your view on whether you need to have a tailored approach dependent upon the different types of suppliers?
Well, I am 100% on the side of preparing a tailored approach for both parties, for the vendors, which I often represent, but also if you're the buyer. And it comes down to that business element of things. We are in a situation here where two parties are trying to come to an agreement to implement a solution, start a service that will benefit both parties. And the sooner, the faster we can get to that point, the better for everyone. And if we, as a privacy team, as the legal reviewers here, the security reviewers, if we limit the time we spend on the low risk cases and shift the focus to the high risk cases instead, that's a better use of our time, and also better, of course, from a privacy perspective, more aligned with a risk-based approach. So I think we have all the reasons to try to go for a more tailored approach that takes into account what kind of risks do we have, what kind of data will they process, how much, what will they do with it, etc., to appropriately respond to those risks.
And I'm just going to ask Dominic this one again. One of the comments, I think, was we also, in higher risk areas, of course, do a DPIA. Do you think, is it just a DPIA, or is it, as Egil's saying, managing risk full stop?
I was surprised, like Egil, at the numbers you read out, because I would have thought more of the people here today would have opted for a tailored approach rather than a one-size-fits-all approach. And it all comes down to risk. What is the risk to the data subjects, and consequently the risk to your business as a customer if you're entrusting your data to a supplier? And the risk isn't the same in every situation. So why would the assessment be the same in every situation? Just to give two comparisons, if you're entrusting a printer to produce some marketing materials and you're supplying them with your customers' names and addresses, and you're entrusting a hosting provider to hold your HR database, including all sorts of sensitive information about your employees, is the risk the same? Should we have the same level of assessment? I don't think so. I would have thought it's appropriate to tailor the assessment, both to manage legal risk and to manage the sort of resources. And so looking at your question, Robert, I think it does come down to the situation, what you need to do. A DPIA of some sort, I would have thought would be appropriate in most situations, but also continuing to understand the situation and understand the risks being posed through whatever level of interaction and investigation would, I think, be appropriate. And this is going to vary from one case to another.
Yeah, and it's interesting. One of the comments we've had in is we use an initial short form, like a pre-DPIA, as I would call it, just to sanity check, is there a big risk or not? And I'm going to move on to Egil for the next question we've had is, what other assurances should we be looking for when risk assessing, in terms of security and location of the vendor, etc.? Do you want to talk a bit about that, please?
Yeah, sure. And I mean, as we touched on here, we do have certain requirements, certain obligations under the law that require us to look at certain things, but also to have this risk-based approach. So we have to combine that with sort of our own assessment on what do we consider to be additional risk areas for different situations, for different relationships. Do we want to look at for certain type of processing, certain type of risk? Do we expect our vendors to have a certain level of measures in place? Do we expect them to have certain certifications, certain documented processes in place? Do we need to have them evidence certain different things? But it comes down to us having a thought through process. So we shouldn't just bluntly ask everyone for an ISO certification or ask for a risk matrix or like a data protection policy from all of our vendors. We should think about first categorizing different situations. So if we have a new vendor that might pose a certain type of risk on a certain level, this is what we expect from them. This is the type of conversations we want to have with them. This is the type of assurances we want to see. Otherwise, it's going to be impossible to manage, and it's going to be very challenging for that buyer in your organization that wants to implement this new solution also. So many times we're seeing people, privacy professionals, who want to start using our services, and they intend to use our services in a way that doesn't really expose them to a lot of risk, but they come back to us and saying, I'm still forced by my procurement department, by the security team, to have you answer this 200-page of security questionnaire and these certifications, etc. Doesn't really make sense to anyone, and it makes their life very challenging because it delays the purchasing process so much. But it's just like the organization has made it simple for themselves, they think, by applying one size fits all for every situation. But it doesn't really work for anyone. So customizing it and expecting different assurances depending on risk introduced, that's really the way to go.
So we're going to throw this one out as well to you, Simon. Anything else you'd like to add on that?
Yeah, I totally agree with what both the guys have said on that. The only thing I'd probably overlay on top of that is also maybe a consideration of the relative scale and maturity of the organization that you're dealing with, and what expectations you might have of a large global tech company, for example, and the measures and processes and standard operating procedures that they might have in place could be quite different to a very small operation that you're trading with. That's 5 people, for example, those kind of things. It'd be very different expectations that you'd have. Equally, they've still got requirements to have the technical measures in place that are appropriate to the processing. But again, it's a factor, I guess, of the of the sensitivity of the data and the type of processing, but equally being mindful of what resources, I guess, that organization has got and what your expectations would be. Just in picking up on kind of the other kind of question that you asked, Robert, is kind of what other assurances will we be looking for? And I'm picking up on, I think Natasha's mentioned on the chat there. So they've said, for example, sometimes they might look at privacy notices, which is quite a common way, I think, that organizations will do, just as a quick look at a privacy notice. But some of the other things that might be considered, again, particularly where there's justification behind it, because I totally agree with what you've been saying about having a tailored approach. But things like you might look for assurances around, say, information security. So things, for example, like certification. Are they ISO 27001 certified? Things like that. What kind of policies and procedures, standard procedures and training have they done for their staff, so that the people that are physically handling client data have been trained and have got policies, procedures to work to? They would be one of the areas that I'd be looking for assurance of. Equally, the standard kind of technical requirements, so around things like confidentiality, integrity, accessibility of the data and availability, all of those kind of things, as well as things like resilience, backups. Have they got backups of all the data? If they had a ransomware attack, for example, can they bring their backups back online quickly? those kind of things, disaster recovery type scenarios. But again, might not be appropriate for every scenario, but certainly in many it will be relevant. And I guess also recognizing that many processors will also outsource. They will also subcontract their processing to other suppliers that are, again, offering specialist services. So I'd kind of be asking what assurance and what assessments they do of their providers, particularly if they're using, particularly large providers. It'd be good to kind of understand what the situation is with those and what kind of regular assurance from their point of view looks like for the providers that may end up looking after a controller's data. Those kind of things. So it's just to give some tips on things that we might look out for. There are many others that you might consider, but that were just some of my short list.
Yeah, and it's interesting. In my experience, we're seeing now in the US, there's a lot of focus on the entire chain. So it's not the immediate supplier, it's everybody downline from the supplier. And there may be geopolitical reasons why you need to drill down, and there may be just pure cyber resilience. And we are going to get, I think, much more pressure over here in UK and Europe to drill down the chain. And I think, and I'm sure Egil would agree with me, if you are a vendor, the sooner you have got your Q&A and your white paper out and so on to ease the process, the better. Okay. So you're doing the due diligence, then it's a matter of having a contract. So Dominic, how valuable is the contract in actually managing or reducing the risk, or is it just a legal necessity?
It should be very valuable if you have the right contract and you do the right things with it. Just picking up on what you're saying about legal necessity, I expect there are probably two situations where you'd particularly be concerned about having a contract from a legal necessity perspective. One we've touched on already, which is where the supplier is a data processor and there's an Article 28 requirement. Additionally, if your use of the supplier involves an international transfer of personal data, and your chosen method of ensuring that that is lawful, if the transfer is to a country that isn't adequate, is contract based, then you'll have a requirement to have a contract, which might have to be supplemented by additional measures to ensure that the personal data is appropriately protected when it's overseas. So there are those key legal reasons. But more broadly, the contract is your means of ensuring that the supplier lives up to all the promises that you would want it to make, and that all the assurances and the good things the supplier has been saying to you during the procurement process. And these can include, obviously, the hard commitments around, for example, security, around continued compliance with the supplemental measures I just mentioned, or continued certification to the data privacy framework if you're choosing to use that. But it does other things as well. It can be your basis for opening up the channels of communication that Egil mentioned before, that allow you to communicate with your supplier, understand how the relationship is going, how the work is going, spot issues before they arise, work out how to resolve those, basically head off problems before they become problems. It's also the vehicle through which you can establish a means for modifying a relationship as requirements might develop. Perhaps your scope of services might change, and therefore your need for assurances and protections might change. Perhaps standard expectations might develop over time, and so you need to ask for different things. The contract will allow you to do that, to work out who's responsible, the cost, all the rest of it. And additionally, the contract can help you allocate liability, so that if things do go wrong, what happens? Who picks up the bill? Who has to take steps to sort things out? There's a whole host of ways in which the contract can be useful, but I think your question alluded to it. It has to be useful. There's no point in signing a contract, putting it in a drawer, and forgetting about it. You need to be prepared to live the contract, to exercise the rights that you have, and stand up to responsibilities that you have, and to make the contract work for you in the context of your relationship, so that you do in practice have the sorts of protections that you're looking for, and can be sure that you do protect data subjects' rights.
So we've had a question in that sort of relates to this. Would you need to do the checks or the due diligence if the vendor's contract already has detailed schedules on their security, their standards, how they manage their staff? In other words, do you take it as read, or Simon, do you really drill down and say, do you do what you say?
I think that's an interesting question as well, actually, Robert. A good one to call. I think it's good news that if an organisation, your processor, for example, has already done that and taken the trouble to already list all of this out for you, it's a positive sign, most definitely, and I think it would give you some level of assurance, most definitely. However, from experience, I do find that some organisations aren't always applying everything that they've put in writing, if I'm completely honest. So I might be inclined, and particularly on high-risk contracts, if I'm doing some high-risk processing that might have some particularly sensitive data, particularly high volumes, and again, mindful of the type of organisation that I'm sharing that data with, I would maybe drill down a little bit, if I'm honest, but it depends on the sensitivity, and ask some difficult questions about, so how do you do that? What does that actually look like? A bit like we have backups in place that I mentioned before. Okay, how quick are your backups put back online? Maybe just a few questions to drill down just to make sure that they are actually walking the walk.
And I come back to you, Dominic, on this one. I mean, you're a large organization, but what do you do if you've got a vendor who is a well-known brand? They say, here is what we do, take it or leave it. Do you just give up, or should you push a little more?
I think we're in a lucky position being a large organisation, and it's a bit easier for us to push for more than it might be for smaller organisations. But again, it's going to come down to how risky we think the situation is. If this is a relatively low risk situation, we may not want to approach it in the same way as if it's a higher risk situation. And certainly even with some very large vendors, we are prepared to ask for more, to certainly ask for more questions and to ask for more protections. And that then forms part of the negotiation and ultimately part of a decision around what we choose to do.
And have you found, and sorry to come back to you again on this, Dominic, but I'll ask the others, have you found in the discussions with the processor that there are occasions where they're not actually operating as a processor, but what you've got here is somebody who has a processor contract but is operating as a controller? Do you see situations where, because they're not necessarily EU based, they're not really understanding the differentiation between controller and processor?
I've certainly had conversations with suppliers and with other third parties about the nature of our relationship. Is there a processor controller relationship? Is it a controller to controller relationship? And it's not unknown for there to be a different sort of opinion to start with. So we talk it through and we come to a common position. It would be difficult to conclude a contract if you don't both have a common understanding of what your relationship is and what's required of that relationship. But it's not unknown that you might start from different positions and have to come together during negotiation.
And Egil, we've had a question come in, which I think the answer is pretty easy. Is a data processing agreement sufficient, or should it be a full-blown contract? What's the actual difference? Do you generally rely on a DPA?
Well, I mean, if you have a vendor that will process data on your behalf as a processor, then yes, you need a DPA, but a DPA will only cover certain aspects of the contractual relationship. So you will need to have that be part of a larger agreement that covers what it is to be, all the commercial aspects and other aspects as well around the arrangement.
Anything you'd add to that, Simon?
Yeah, that's what I found too. Often there's a master services agreement or some form of contract like that, and therefore the data processing is either an addendum to that, or as you say, a separate DPA that runs alongside it that really clarifies the data protection obligations. The only times when I found there can be a bit of a challenge is sometimes I've seen master services agreements that also cover a little bit of data protection, but not enough to comply with the law, or not enough to do the due diligence that you might want. And then you might get a conflict and end up trying to remove it from the master services agreement. So it's just something I'd watch for, I guess. But I see the two running in parallel. The data protection covers the specific obligations that you have from a data protection point of view, and there may be others, again, to cover other areas of compliance that sit alongside the MSA.
And it's not a question that has come in, but it's one I got asked yesterday with a client of mine that is definitely a processor, and they do marketing calls and marketing on behalf of their clients. They've got a situation right now where they have a customer who is saying, we would like to get you to do marketing for us and after sales care calls, but you're not a processor, are you? You're a controller, and we are not signing your standard terms. How do you persuade somebody that does not understand the difference between the EU controller and processor, Egil? I mean, do you just quote the sections of the GDPR?
No, I don't think that's enough. I mean, that's tricky enough for European-based lawyers and privacy professionals. In many cases, we've seen that. You have to drill down what is really happening in this situation. What kind of data is being processed? Who is really in control of the processing? Who determines the means and the purposes here in this situation? You need to have that discussion, and together, like you said, Dominic, find common ground on what is happening, who's in control, and what does that mean in terms of nature of this relationship, and then you can come to logical aligned position on how to define the contractual arrangements as well.
Can I touch on that as well, Robert?
Yeah, no, and actually I wanted to also just throw out to you as well, Simon, so take this as another one, is we see a lot of contracts that say simply the parties will comply with all applicable privacy laws. Is that worth the paper it's written on?
Not a lot, in my opinion. I wouldn't be particularly happy with that kind of approach. I'd be looking for a bit more detail behind that. But I hope that kind of answers that question for you. The other point that I was going to make, where I've seen this confusion about, not just confusion about controllers, processors, and who's what part, is that I've seen organisations that are clearly a controller insisting that their supplier, as such, their processor, is in fact another controller, is a separate controller. And the purpose of doing that is to push the obligations of the law onto their processor and to make the processor ultimately responsible. And it tends to happen where it's a very major service. And I won't mention the specific industry that I'm talking of, that I've come across this quite a bit. But I think it's something particularly for processors to be mindful of, is where your client is insisting that you're actually a controller when in fact you're not. And this organisation kind of struggled with this a bit because they hadn't realised what obligations they were taking on by accepting that they were a controller, and in fact had already signed a number of contracts to accept that they were a separate controller. So I'd just be mindful of that if you're a processor. Accepting that you're taking controllership of data presents its own set of risks for you as an organisation.
Thank you for that. We've had a question in, and I know, Dominic, you mentioned Article 28, and the question is, do we have to effectively write all of Article 28 obligations into the contract?
The Article 28 obligation is to have a contract that covers all of the points in Article 28. So they will all need to be covered. But I don't think by themselves they are sufficient. If we take audit rights as one example, how often can the customer audit? What sort of notice does the customer have to give? Who pays for the audits? Various questions arise from all of the implications of Article 28. So I would go further. I'd say you have to, one way or another, write all of Article 28 and consider all the things that follow from Article 28 in order to have a properly functioning relationship if you want to succeed at that. It might be that you have a very small scale contract, very low risk, and you might feel in the circumstances it's appropriate not to trouble yourselves too much further. Using my audit example, if there's a one-off transfer of data to a supplier which will do whatever it's going to do and shortly after return or delete the data, you may feel less pressure to worry about things like an audit than an ongoing relationship. But you shouldn't certainly do less than Article 28.
I fully agree on that. Just a second, because I like what you said also earlier, Dominic, about using the contract sort of as a way of avoiding uncertainty, preparing for how to manage different situations, avoiding uncertainty and being prepared for managing uncomfortable situations if and when they arise, and to use the procurement contractual negotiation process as a way of agreeing on those how to manage those situations before they occur will save you a lot of trouble for when they do actually occur.
And I'll come to you again on this one, Egil, but we've had several comments from delegates about, with a lot of suppliers, a lot of vendors, this gets hugely complex. Somebody said we keep quite a detailed register of the different vendors, and to be fair, it ought to be dovetailing with your record of processing activities. But practically, how do you find, Egil, what vendors are out there, or how can you streamline this audit process?
Yeah, no, but so I mean that comes back to, I think it's managing this is partly about managing your legal obligations, but it's equally much about supporting your organization. And in order to do that, you have to make it easy for the people who are actually evaluating, buying, implementing new solutions. Make it easy for them to give you the right information at the right time, so you can assess if this is a high risk vendor, if this is a medium or low risk vendor, and what are the next steps from here. What additional information do you need? When do you need it? How do you need to be involved in the process in order for making it easy for the buyer to choose the right vendor and implement the right vendor and start working with the vendor? So, and there was also this discussion question earlier here about a pre-DPIA, for example, and some opinions about, well, one size fits all can actually fit early stage at least. And I agree with that. So we see a lot of our customers who are successful building efficient workflows. They have like one very basic questionnaire that is used by anyone who is contemplating implementing a new solution, buying something new from a vendor. Just sharing some basic information about who is this vendor, where are they located, what will they do, will they process our data, what type of data, how much, what is the value, etc. Very early in the selection, in the procurement process, have that information go to the right folks in the privacy team or legal team. And then based on that first initial information, which is very easy for the buyer to provide without having to do a lot of discovery work. Easy to find out information that helps the privacy team decide, okay, what are the next steps? Should we be involved at all? How much should we be involved? Should we prioritize this? How important is it for the business? What is the timeline? What is the risk, etc.? That way you can build a process that makes sure that business runs smooth and you can prioritize your time efficiently. But building a workflow that involves the organization, that is integrated in actual business processes out there, making sure that you collect the right information at the right time and that the right stakeholders are involved, that makes it so much easier and more efficient also from a risk management perspective.
So it sounds like you're responding, or you're answering one of the comments that we've just had, which is, my worry is we're always seen in the DPO role as the blocker. But you're saying actually you need to be in a situation where you're working as one team with IT and procurement and risk and so.
I guess, yeah, the question of what should the proper DPO do in this, that's for another discussion. They should probably just overlook and provide some guidance on how this should be managed. But the privacy team should be involved in setting a process and defining a risk on different types of vendors and what do we need, what type of due diligence do we need. But they have to make it easy for first line, like the people actually using and buying and implementing new solutions, have to make it easy for them to identify risk and escalate very early on in their processes. That's how you can support them, because otherwise you will spend far too much time as a privacy team on sending and responding and discussing security and data protection matters with every single vendor, reviewing agreements and spending too much time on the wrong deals and the wrong projects happening in the organization.
So we've got another question. What can suppliers do to fast track the onboarding process with new clients? Simon.
I think there's actually quite a bit that suppliers can do, and there's maybe two areas that I'd think of. One, we've talked about how can we streamline this contractual process. So the supplier, obviously, it depends on, again, if they offer a wide range of different services or if in fact they've maybe got a core product or service that they're offering. But in those situations, if they've got, a core product or service, they can develop a data processing agreement that they can provide to their client that covers all of the fundamentals, all the requirements for that client to then use. Otherwise, then, because that covers the bespoking of the agreement, saves your client lots of time because it's all pre-built for you to cover the types of services. That would be the first thing. And the other thing that I really am a bit of an advocate and a fan of doing is for businesses, and particularly I think this works for technology businesses, but may well apply to many others, is to produce like a fact sheet or FAQ that summarizes the key points that can be shared amongst maybe a decision-making team, can maybe be shared between whoever's relevant at your client, who needs to know the answers to the core questions, like, things that we've been talking about. So where are we based? Have we got any certifications? How do we protect your data? That covers the things, the reasons why clients send you these massive, great GDPR questionnaires that often have all sorts of questions that, particularly for smaller businesses, are not always relevant. If you can build something yourself that maybe is a sheet of A4 or a couple of sides of A4 that answer the core questions that actually your client should be asking of you, you've taken a lot of the legwork out. I appreciate you doing it yourself, but hopefully that can be reused and it can really help you onboard new clients and save a lot of time. And I'm sure would be appreciated by many of your clients because it's made life a lot easier for them and helps them with their own internal risk assessment and helps to provide that assurance for them.
So a number of comments have been made about how we as the controller do a DPIA where it's appropriate. So would it not be reasonable for a vendor to have done a DPIA that they can share with a customer?
Is that for me again, Ron?
Yeah, that's for you, Simon. Sorry.
So, yes, I've seen situations like that. I've worked with a few vendors, to be honest, to create either a DPIA or maybe a legitimate interest assessment to effectively conduct your own assessment around what are the most common use cases for your clients, so that you can share that information with them.
Okay.
To be able to demonstrate again that the appropriate technical and you've considered the rights of individuals and that you've effectively done that legwork for them. I think that's a really good approach.
Okay, good. We've got time for a couple more questions. I'm going to go to Dominic. So assuming you've got the contract, you've done the due diligence, you're now in the working relationship, how much should you be doing during the ongoing relationship? How regularly should you kick the tires?
I think it's a question of an ongoing relationship rather than kicking the tires necessarily on a regular basis, which implies not doing something in between. Certainly with an important contract where there's a high level of risk, having an ongoing conversation with the supplier to understand how things are would seem appropriate, and not just for data protection reasons, but just to understand that the service that's being provided is working. The last thing the customer business is going to want is to find its service has stopped working regardless of data protection. So establishing those relationships and keeping channels of communication open constantly is important. I think though at a more formal level, if the contract allows audits let's say every year, consider an audit every year. You might choose for good reason not to, but then again, if you've got the right, at least consider exercising it. And again, depending on the level of risk posed, maybe consider putting in a sort of halfway position of not really an audit, but maybe just making a point of asking some particular questions at a more regular frequency in order to assure yourself that things are working as they're supposed to.
And anything you'd like to add to that, Egil?
Not really, but I think, again, yeah, fully agree. It comes down to what kind of relationship, how important is this, and to focus on those relationships where it's not enough to know that something just says A or B on a piece of paper in your contract, but you actually need to know and that, yes, this process is working. They are actually doing this. If you are truly dependent on them, then you should also spend time making sure that it actually works as intended. That's part of your business continuity plan. It has to be.
Yeah, and Simon, did you want to add?
I only wanted to add that there's another relationship I think we should think about here. So if you're in the privacy or legal team, for example, the other relationship is whoever's contracted the service, the people that are primarily using that service and staying close to them, because they're going to be aware if they're having any problems with that provider, any service delivery problems or anything that you may need to be aware of. So maybe they're going to be closer to it, I guess, on an ongoing basis than you are. So keeping those lines of communication open and maybe having those kind of reviews internally before you contact this provider might be appropriate.
Yeah, and actually I was about to say, I think the strap line is be proactive rather than reactive. And off the back of that, the last question I've got before we wrap up is, unfortunately, it seems we've all been reactive recently to the sudden rise of generative AI, large language machines. Dominic, how concerned should we be about how our downline is using AI in the deliverables that we're getting from the suppliers and so on?
I wouldn't want to be concerned in the sense of being worried about it so much as being curious about it. I think it's important to understand where it's used, how it's used, what the consequences are. Coming back to the fundamental point here, it's all about the risk to data subjects and consequently the risk to the business that is responsible for processing their personal data. So definitely ask questions about that and make sure you understand what's going on. That will then feed into how you should respond to it, which could vary from asking for it not to be used, choosing another supplier, towards other measures to ensure that it's properly regulated so that the risks are manageable.
Thank you. And yeah, Egil, do you want to add to that?
No, but I agree. I think, like, if you as an organization are concerned about using AI, for example, in your own organization, then you should be equally worried about your vendors using it. Privacy risks related to new technology exist regardless of who uses the technology. But I agree on, like, you should be curious. You should make sure that these things are discussed, that you understand what is happening, how will it be used, what risks that lead to for us and from you from a legal, contractual, ethical perspective, and you should make conscious decisions around it. And I think as a vendor, the best thing you can do right now, when it's early days, is it's being transparent about what are we doing, what do we know, what don't we know, what risks do we see, what could you be interested in, and let's have an open conversation about it. It's still so early days, and where everyone is trying to find the right stance and position on this in the market. We recently at DPOrganizer announced new product launches where we have a lot of new AI involved. And it's super exciting from a product and technology perspective, but we know that there are issues here, challenges. So and we can't figure everything out. We don't know everything yet. But the best thing that we can do is that we can have very open, transparent discussions with our customers to say, this is how it works. This is what the technology does. This is what we know. This is what we don't know. And we want you to understand this so we can both manage our own risk appetite appropriately.
And do you want to add to that, Simon?
Yeah, I think you've summed it up very nicely, actually. It's again just, I don't think I'd add anything new, to be honest, to what's already been said on that one, Robert.
Okay.
Thank you.
I was just going to add to the question about how do you as the supplier ease the process, to just say I have a client who is subject to GDPR. They're a US-based vendor. At the start of GDPR, they were getting huge pressure from big customers saying, you need to put in place A, B, C, D, and E, otherwise you don't get the business. They have done that, and here they are 5 years later. They have used their compliance to sell themselves as against their competitors, and their revenues have increased 30% year on year. So, they have seen the return on investment of trying to anticipate what the customer's needs are. We're coming towards needing to wrap up. So I'm just going to ask Dominic if he'd like to make any closing remarks, and then I'll go to Egil, and then I'll hand to Simon. So Dominic, over to you.
Thanks, Robert. I think coming right back to your questions at the beginning around whether there should be a one-size-fits-all approach or a tailored approach, I would reiterate the point that we've discussed a number of times in the past hour, that the risk isn't the same in every situation. So a tailored approach is probably the better one. Looking at some of the comments that have come up, I think your suggestion, Robert, of a pre-DPIA as an initial fact find seems to be widespread or widely adopted, and I think that does sound like a sensible approach. And if that's what people mean by one size fits all, then that I think is the right one size fits all. But beyond that, it's important to consider what you learn from that pre-DPIA and tailor your approach accordingly.
Thank you. And Egil.
Yeah, no, but I would like to make sure that we keep in mind that ultimately it's about supporting the organization in finding reliable and good vendors so that we can support business and our customers. And in order to do that, we have to make sure that we get in early and get access to the right information. We shouldn't wait until the last step once the buying person has decided on a vendor, and then when you start discussing these things. No, you should make sure that the buyer knows already when they start their evaluation what information do they need to provide you, and when and how. And we also try to do that as a vendor. We try to support privacy professionals coming up to us, and we ask them during the first meetings, when we know that we want to go forward, what will you need from us? How can we support your buying process? What information do you need? Who do we need to talk to get through the security questions? Because we know that can take a lot of time and delay a buying process, which is good for no one. So get these things going early on in a procurement process. Thank you. And over to you, Simon, to close.
That's great. Thank you all very much. Thank you, the audience, for everyone that's listened in today. Thank you guys on the panel. The only thing I'd just add from that point of view is I totally behind you what you've said about not applying a one size fits all, that the risk profile will be very different. I also agree that this approach to having a standard kind of a risk evaluation form, let's call it that, with some basic questions to get an idea. Personally, I quite like to do that face-to-face on a telephone call as well. I have my own set of questions that I work with clients or pass to clients to use that will ask the same kind of thing, that will quickly get a grasp of which projects have got some big risks and which ones are small ones, to get an idea of that. But each to his own. We'll have a different way of doing it. But so thanks everyone for attending today. I hope you found it really useful. We better close off there. I'm sure some of you have got meetings to go to, so I'll say goodbye now. Thank you. See you again.
Thank you. Bye.
Bye.
Bye.